Articles 124 to 147 of the Constitution lays down the composition and jurisdiction of the Supreme Court of India. The Constitution enables the Parliament to increase this number, which is originally the Constitution provided for the Chief Justice and 7 lower-ranking judges, whereas but now the Constitution enables the Parliament to increase the number of Chief Justice and lower ranking judges. By 2008, the number of judges has been increased from 8 to 30. By 2019, there are 34 judges, including Chief Justice. As to the appointment of the Supreme Court judges, the Chief Justice of India should consult the collegium of 4 senior most judges of the Supreme Court. The collegium makes decisions in censuses. Every judge of the Supreme Court is appointed by the President after consultation with the Cabinet and the judges of the Supreme Court. And such judges will hold office until they attain the age of 65 years. If any of the judge wants to lay down the office, he can do through and hand written signed resignation letter to the President. A Parliament can remove a judge in impeachment to be considered for the office of a judge. One must be a citizen of India, and this question is for the Parliament's decision. And should have been a judge of High Court for at least a period of 5 years, or advocates of High Court for 2 or more such courts in succession for at least 10 years, or the person must be in opinion of the President, a distinguished jurist. In 2007, Justice K.G. Balakrishnan became the first Chief Justice of the Supreme Court from the scheduled caste community. The Supreme Court of India, under the present Constitution, commenced functioning on January 28, 1950. It was placed then in the Chamber of Princes in the Parliament. It moved to the present building in 1958. Harilal J. Kannaiah was the first Chief Justice of the Supreme Court. The other judges who assumed office along with him was Judges Syed Fazl Ali, Patanjali Sastry, and Meher Chand Mahajan, Bijan Kumar Mukherjee, and Nisar Das. The High Court is the head of the state judicial administration, and every constituent state is expected to have a High Court. However, at present 4 High Courts have jurisdiction more than one state. Among the Union Territories, Delhi alone has a High Court of its own. Other 6 Union Territories come under the jurisdiction of nearby state High Courts. Each High Court comprises of a Chief Justice and other judges. As the President may from time to time appoint, the Chief Justice of the High Court is appointed by the President in consultation with the Chief Justice of India and the Governor of the state. In appointing other judges, the Chief Justice of that High Court is also consulted. The judges of the High Courts hold office until they attain the age of 62 years and are removable in the same manner as judge of the Supreme Court. To be considered for appointment as a judge, one must be a citizen of India and held a judicial office in India for 10 years, or must have practiced as an advocate of High Court. The High Courts have original and appellate jurisdictions in cases arising within the territories of the state. So the High Courts are the party of single and integrated judiciary system. They are completely independent judiciary institutions. The Supreme Court has no direct administrative control over them. The High Court too has the power to issue writ in cases, not only the Supreme Court. The High Court too has the power to issue writ in cases involving fundamental rights. Legal rights of safeguarding fundamental rights. Both the Supreme Court and the High Court have the power to issue writs with a view to ensure quicker justice. Habeas corpus literally means demand to first produce the person in body. It cases where the person is alleged to have been illegally detained. This right safeguards personal liberty of every individual, minimizes a government to act lawfully and to resist from penetrating an unlawful act. It is meant to direct any authority to perform its legal duty, may be issued against any authority, officers, government or even judicial bodies that Taylor refused to perform a public duty and discharge a legal obligation. Prohibition to issued by a high court to a lower court or tribunal for prohibiting it from exceeding its jurisdiction. Writ of prohibition is issued only against a judicial or quasi-judicial body. Century to lies against the judicial or quasi-judicial authorities. It means to be informed. The writ of century is quashed is to issue to quash illegal orders of judicial or quasi-judicial bodies. So it means to be informed. Century means to be informed. This co-warrant is a question asking what authority or warrant. This is meant to ascertain the legal position in regard to claim of a person to hold a public office. Besides these reads, the High Courts under Article 226 may issue other directions and orders in the interest of the justice to the people. Judicial review, public interest litigation, and judicial activism. The Supreme Court and the High Courts are entrusted with the power of judicial review. This Parliament and state legislations which contravene constitutional requirements have been struck down by judiciary. Um, Public interest legislation. Any citizen of India can approach the courts for public case uh, under, by filing a petition under the Supreme Court by Article 32, in the High Court under Article 226, and in the Magistrate Court under Section 133 of the CRPC.